Hello everyone. So let's discuss some more cases in line with the last session, wherein we were discussing the cases on the provisions of code on wages. So let's just continue it. Let's see some more cases in the same line. So there is one case named Municipal Corporation versus N.L. Abhyankar. The citation for the same is 1979 IILLJ 258 Bombay. What happened in this case is there was a representative union of the worker in, of course, Bombay, and this particular representative union requested the employer to collect some levies from the employees, the wages of the employees, and remit it to the representative union. Now employer refused to do so, and against this, union filed an application to the labor court requesting the court to order the employer to accept their request. There were certain levies which were due to the representative unions of the employees, and the employees who were part of those representative unions of this particular employer, from their wages the deduction was sought by the representative union that please provide us the money from the the amount of the levies from the wages of such employees who are working in your this thing establishment. So the labor court definitely ordered in favor of the this representative union, and employer ordered the employer to collect the rebate indemnity to the trade union. Now the employer went to the Bombay High Court against this order of the labor court that this is not a justified deduction under the Payment of Wages Act, and hence it should not be considered as a a proper deduction, and he shall not do the same. So the Bombay High Court stated that if there is any order from any court, it would be considered as an authorized deduction, and hence it has to be followed, and it won't be considered as a unauthorized deduction. So he may go ahead with the same. So this was the case on what do you call the orders, deduction on the basis of the orders or orders of the authorities or the court. Now there is another case that we have to see is of MP High Court. It's a very interesting case named Nathulal versus MP State Road Transport Corporation. Nathulal versus MP State Road Transport Corporation. The citation of the same is 1986 IILLJ 255 MP. Now what happened here is this guy Nathulal, he was a driver of this Madhya Pradesh State Road Transport Corporation, and one day he met with an accident while driving the vehicle of this MPS RTC. So on such on like while coming when the MPSRTC got to know about this, they directed the driver to pay a sum of rupees 3,700 rupees as damage to the transport corporation, and it was directed to him that he shall pay this in the monthly installment of 25 rupees from his salaries that he received from in every month, right? So this was challenged by this guy Nathulal, who was a driver, and it was held that the deduction for the damages was deduction for the damages only when the damages or loss is directly attributable to the negligence or default of the employee is justified. Here, this driver was not given an opportunity of being heard or showing cause, and there is no negligence or there is no default of the employee can be found, and hence it was held by the Madhya Pradesh High Court that this deduction is not valid, and the order of the deduction was quashed by the Madhya Pradesh High Court. One another judgment that we have to discuss is of Prakash Chandra Johari versus IOB and others. The citation of the case is 1986 IILLJ 496 Rajasthan, RAJ. It's a judgment of the Rajasthan High Court. What happened in this case is there was a godown keeper of IOB, Indian Overseas Bank, who had worked for 30 minutes on one particular day and 4.5 hours on the second day in one particular month. And on this, this lesser working hours or less work which is being performed by this godown keeper, the bank deducted wages for 2 days, for the day when he worked only for 30 minutes and the day when he had worked only for the 4.5 hours in a particular day. The employee filed an application to the authority which was established under the Payment of Wages Act. The moment it is a 1986 judgment, of course. So it was held by this authority that the deduction for the period when he has actually worked is not valid, and hence if he has worked for at least 30 minutes or if he has worked for 4.5 hours, the bank should not deduct any amount for those hours when the employee has actually worked. So 5 hours wages shall be paid to the employee. Now the employee filed a writ petition for the full day's salary and to the Rajasthan High Court, and it was dismissed. Then the employee again filed a special appeal to the Rajasthan High Court that his 2 days wages shall be paid. Now on this, Rajasthan High Court dismissed the special leave of the employee, this godown keeper, and it was held that bank is justified in deduction of the 2 days wages even. So there shall not be any single penny which shall be paid to this guy for non-working and for remaining absent for the 2 days because he worked for lesser duration, because by interpreting that the absence of the provision of the deduction says that absence of employed person from the place or the places shall render a deduction, and hence it should be considered as a valid deduction. However, this may not be applicable now as per the provisions of the Code on Wages, because there is an explicit provision which states that if in case the if in case the employer is deducting the amount for the with the reason of absence of duty, the deduction shall be only for that actual absence and not beyond the absence of or not during the time when the worker has or employee has actually worked during the employment. One another and last case is case of Good Loss Narrow-Leg Paints Limited versus Paints Limited Mumbai versus Paints Employees Union Mumbai. The citation for the same is 2002 1 BOMLR 514. What happened here is a company and one union signed several settlements, and there were certain biasness which were claimed by the union were going on from the side of the company towards the employee, towards the members of that union who were the employees of the company. And in the same line, the company had started deducting the wages of those employees who were part of that union. And one day there were two employees named Puran and Ramesh, who were the skilled workers in the varnish department of the company, Narrow-Leg Company of the Bombay. So this Puran and Ramesh were asked to do some job, and they did not carry out that work which was allotted to them for that particular day, and the wages for that particular day were deducted by the company from this two employees who were part of that particular union, with which it was alleged by the union that there is a biasness which is going on between the employees of the member employees of that particular union and the company's employer. So the matter went to the industrial court, and it was held by the industrial court that the employer is definitely practicing the unfair labor, which is we have already seen in the Industrial Disputes Act. So it was held that the employer is practicing unfair labor practice, and it was directed to the employer that he shall remit the the deducted wages to Puran and Ramesh both for that particular day. Now, employer filed a petition in the Bombay High Court that his reduction is valid because the employees had not, or employees had rejected to work on a particular day, and hence it should be considered, the deduction should be considered as an authorized deduction. Now, the Bombay High Court held that both the workers had refused to do the job of filling of the containers, as it was the job of a junior worker, and these two were the skilled workers who were working in a particular department, and hence the job which was offered to them for that particular day was lowering the designation or the standards for what they were working, and hence it was refused by them. So the Bombay High Court held that the company had, without any inquiry made, ordered or directed for the deduction, and hence the deductions were not justified, and it was quashed by the Bombay High Court. So with this we are done with unit 1, that is module 1, which consists of the concept of payment of wages and the concept of minimum wages. In the next session we shall discuss the provisions of or we shall start working on module 2, which is on the bonus, and the provisions of the bonus in the code on wages again shall be discussed in the next session. Till then, thank you so much, and I would request all of you to take care of yourself and conduct some research, and study hard at home, and of course follow the latest judgments and the barracks, and keep your barracks ready with you for all the forthcoming sessions of labor and industrial laws too. Thank you so much.